Have you ever wondered what happens when you sit down to write a song with somebody and you don't have an agreement? Who owns the song? How much of the song do they own? What if somebody's just hanging out in the room when the song's written? Do they own any of it? What about the sound recording? Who owns the sound recording when you have 4 people in a band and they all play on the record and they don't have any special agreement with the producer? Does the producer own it? Does the drummer own it the same as the singer who wrote it? Today we're going to answer all these questions and dive into joint authorship of songs and sound recordings. Okay, so what are we talking about here? There are situations where songwriters get together and they'll co-write a song. And if they don't have a written agreement that details, everything that they're going to do after they write the song in terms of the publishing and the administration and all that, and more importantly, who owns the song, how do courts decide who actually has the ownership? And how does that apply in the context of a sound recording too? Well, they use the same rule, and that rule has a 2-part test. Here it is. Number 1, there must be an independently copyrightable contribution from the person who's claiming to be a joint author. We'll get to what that is exactly here in just a second. Number 2, the parties must have all had the intent that the other party was a joint author, which is a little bit confusing, and we'll dive into exactly how courts have interpreted that as well. First, let's talk about the independently copyrightable prong of the test. When it comes to sound recordings, courts have said that if you want to be able to make the argument that you're a joint author, you have to actually play something that goes on the record. So, whether you're playing keys on something, you go in and you shake a shaker, right? Or maybe it's just you in the background going, yeah, whatever, it doesn't matter. You're on the record somehow. Or if you're an engineer, courts have found that just, doing your engineering duties on the album and setting up the microphones for recording, that can be enough to be an independently copyrightable contribution. When it comes to compositions, courts say the same thing, and basically the question is just, did the person who's claiming to own a portion of the song actually contribute to writing it? And if so, can they point to the part that they contributed? You might have a dispute of fact about whether they actually did contribute that part, but that's the question. What part did they contribute? And it has to be independently copyrightable. So, meaning it has to stand on its own, whatever the part is that they contributed. Overall, the first prong is a pretty low bar for someone to reach if they want to be able to make an argument for joint authorship, as long as they can prove it. The second prong is a little more tough. All of the authors must have a mutual intent that the other authors be co-authors. So think about how this plays out. If you have 2 people sitting together and they both make independently copyrightable contributions to the song, but let's say the one person is a huge superstar singer-songwriter and the other person is up and coming and has no credits to their name, did the superstar really intend to co-write with this other person? So courts in some cases have said no. All right, so let's talk about an example of that. The easiest one is the Jay-Z case and the song Hova, H to the Izzo, if you're familiar with that song. So the woman who sang the counter melody that you can hear in the chorus of the song, she was in the studio and just hanging out. Somebody invited her to go sing and get on the mic. Jay-Z asked her to do that and really liked what he heard from her. He paid her something for her time there. They did not have anything in writing or any contracts. They then released the song with her vocal on it, and she ended up suing Jay-Z and his record label. She claimed that she was a joint author of the sound recording because of the contribution that she had for the song with her vocal. But the court determined that even though she did have an independently copyrightable contribution, that Jay-Z did not intend to be a co-author with her. So, it's kind of easy in the example of, Jay-Z, who's a superstar, and this person who's just starting in the music industry. And this is really a cautionary tale to have documents anytime someone's going to perform on the album who you don't know, especially to go ahead and wrangle in those rights. But ultimately, the court found that this woman was not a co-author of the song because Jay-Z had this subjective intent that she not be a co-author. Now, if that's true, and this is the standard courts are using, which is still currently good law, then that means that there's a subjective veto opportunity. If you're a smaller artist working with a bigger artist, you need to get some sort of proof that the bigger artist is cool with, actually views you as a co-writer, because if you don't have anything in writing and they assure you all the way that it's, 50-50 or 70-30 or whatever, they could potentially, make the argument that they never intended to be a co-writer with you. So something to consider. But there's another case that has to do with KRS-One, the rapper, where he had a live show in San Francisco, and the court found that the engineer who set up the microphones for the live recording could be a joint author. They remanded it back to the jury, and ultimately the case was settled. But the point is, KRS-One was not able in that case to do what Jay-Z did and simply say, no, I did not have the intent that this person be a co-author of the sound recording. So it's highly fact intensive, and it really depends. But the best thing to do when you're working with someone on a professional sound recording or song that you're, if it's more than a hobby, you should have a document and make sure that everybody signs it so everyone's clear about exactly what the rights are. Finally, I want to cover a couple of more just little sub-points from a few other cases. So we've got the Better Than Ezra case, okay? It was good, pretty awesome song. They had a few other pretty good songs as well. But their drummer quit the band, had a falling out with the band, and sued the band for co-ownership of the sound recordings, which included their hit record that had the aforementioned good on it. And the court found that the drummer had an independently copyrightable contribution. He's playing drums on the record, and he's part of the band. So, there was a mutual intent, at least at the time the song was recorded, that he be a co-author. So the court found that, in fact, a drummer in a band that plays on the record is a joint author, even if that drummer didn't write the song. One final point. Financiers who pay for the recording process are not eligible to be a joint author solely because they put up money, okay? So if someone pays for the recording and then they want to make the argument that they're really a joint author because they contributed to it, they're going to fail in that argument. And the reason why is, even if you were able to succeed on the mutual intention, the second prong, they did not actually provide any independently copyrightable contribution. So that's why that fails. So in summary, make sure that you have documents when you are working with people on songs and sound recordings. If anyone has any questions about anything, feel free to reach out to me, Matt@CrumptonLegal.com. I'll talk to you soon.